Section 10. Legal Hotline Q&A, Fair Housing Practice. In the Market Introduction, Real Questions, Real Liability. As we wrap into one of the most practical sections of this course, we move into real-world legal scenarios that agents face every day. This section is designed to feel like a call into a legal hotline, because in reality, these are the exact types of questions agents ask when they are unsure how to proceed. In 2026, the difference between a compliant agent and one facing a complaint often comes down to how they handle situations like these. Fair housing is rarely black and white. Instead, it is highly fact-specific, requiring agents to apply the law carefully and thoughtfully. Let's walk through these scenarios and break them down so you know exactly how to respond in your day-to-day business. Scenario 1. Age-restricted community versus disability. A buyer wants to purchase a home in an age-restricted community but has a disabled child who must live with them. The question becomes, can the community deny the purchase? The answer is probably not. While age-restricted communities are generally exempt from familial status protections, that exemption does not override protections for individuals with disabilities. In the case of Kennedy v. Prescott Canyon Estates Homeowners Association, the Arizona Court of Appeals ruled that refusing to allow an underage disabled person to live with their parents violated fair housing laws. The court determined that the Homeowners Association failed to provide a reasonable accommodation. This scenario highlights a critical rule. Disability protections often override other exemptions when reasonable accommodation is required. Scenario 2. Buyer letters and fair housing risk. A seller receives multiple offers, and some buyers include personal letters introducing themselves. The listing agent then asks other agents if their clients would like to submit similar letters. Did the agent violate fair housing laws? Not directly, but this creates significant risk. Buyer letters often reveal personal information such as family status, religion, or background. This information could influence a seller's decision in a way that violates fair housing laws. The safest and best business practice is to avoid requesting or encouraging these letters. If a buyer voluntarily submits one, that is different, but actively soliciting them can expose both the agent and seller to potential discrimination claims. The key takeaway is simple. Remove any information from the transaction that could introduce bias. Scenario 3. Reserved parking as a reasonable accommodation. A tenant with a mobility impairment requests a reserved parking space close to their unit, even though the property only offers unassigned parking. Must the landlord grant the request? Yes. Fair housing laws require landlords to make reasonable accommodations when necessary for a person with a disability to fully use and enjoy their home. Even if the property has a standard policy of unassigned parking, that policy must be adjusted if it creates a barrier for a disabled tenant. This is a perfect example of how policies must be flexible when accommodation is needed. Scenario 4. Disclosure of a home care facility. A buyer is considering a home near a facility for troubled teenagers. The question is whether the agent must disclose the presence of that facility. The answer depends on whether the individuals in the facility are considered disabled under the Fair Housing Act. If the teenagers are simply described as troubled, they may not meet the legal definition of a disability, and disclosure would likely be required. However, if the individuals are classified as having a disability under federal law, disclosing their presence could be considered discriminatory and therefore prohibited. This scenario highlights one of the most complex aspects of fair housing. The facts matter and definitions matter. Why these scenarios matter in your daily practice. Each of these situations demonstrates how quickly a routine transaction can turn into a legal issue. The challenge is that there is often no clear yes or no answer without analyzing the details. As a real estate professional, your responsibility is to recognize potential fair housing risks, avoid introducing bias into transactions, apply reasonable accommodations when required, seek guidance when situations are unclear. The best agents are not the ones who know everything. They are the ones who know when to slow down and ask questions. When in doubt, seek guidance. Fair housing situations are often highly fact-specific. What is legal in one scenario may not be legal in another. This is why brokers and agents should consult legal counsel or their designated broker when faced with uncertainty. Making assumptions can lead to serious consequences, while taking the time to verify can protect both you and your client. In 2026, professionalism means knowing your limits and making informed decisions. Online discussion. Question 1. Why might a disability override an age restriction in a housing community? Answer: because fair housing laws require reasonable accommodations for individuals with disabilities, even when other exemptions apply. Question 2. Why are buyer letters considered risky in real estate transactions? Answer: because they may reveal protected class information that could influence a seller's decision and lead to discrimination. Question 3. What should an agent do when faced with a complex fair housing situation? Answer: consult with their broker or legal counsel before taking action.